More likely than not, that 0.01% is all it takes to tip the scales of justice. Join us as Inner Circle legend Charla Aldous, Eleanor Aldous, and Caleb Miller walk you through the critical moments, big decisions, and bold strategies that win high-stakes cases and show you how to turn that 0.01% into a game-changing verdict. You're listening to the podcast where winning is more likely than not. Produced and powered by LawPods.
Hello, welcome to another episode of our podcast, More Likely Than Not. Today, we are thrilled to have Jesse Wilson, trial consultant and author of, I think, a couple of books, right, Jesse?
Yeah, two of them.
Two of them. One is that you can get it through Trial Guides, The Most Important Juror, Embrace the Winning Story in Jury Selection, Opening Statement, and Rebuttal. And another book, Witness Preparation, How to Tell the Winning Story. And Jesse actually travels across the United States helping lawyers reach record, and I mean record verdicts and settlements, and has reframed how we need to think about our clients, taking them from victim to victor. I'll never forget the first time I heard you talk about it, Jesse, and it totally reframed the way that I approach my clients from the first time that I meet them. You work with lawyers, as I said, all across the country, but before we get into your work with lawyers, tell us about your background.
Well, first of all, thank you for having me, and it's good to see you again. I think the last time I saw you in person was, I want to say it was at the Inner Circle
It was
program.
the Inner Circle.
Yeah. So it's great to see you again.
Let me tell you this real quick. One of my favorite
please.
things with you speaking at the Inner Circle is you started dancing and trying to get everybody to dance. I loved looking around the room at those that would dance and those that wouldn't. It was
Those that would
absolutely
dance
wonderful.
and those that wouldn't. Yes.
Yeah, exactly.
Right. Yeah. There was a practicality to that beyond just a weird warm up, but some did dance. Some did
It
dance.
was great.
Yes. So my background, I've been doing this work working as a full-time jury trial consultant for the better part of about 15 years now, and it's still a mystery to me, a beautiful mystery, how I ended up working with attorneys. If you would have told me that, well, more than 15 years ago, I would not have believed you. I would have told you seriously smoking something. So my background is in theater. There's a few of us out there who we're cut out of the same cloth. There's David Ball and Joshua Carton, and everything I knew about the world. And the one thing that I was actually really good at was theater. It's the one thing that made sense to me. And grew up, born and raised Hollywood, California. I went to New York to study theater full time and got my butt handed to me at the Julliard School. And then my life took a dramatic turn. I mean, it's, what's that whole line that we make plans and he laughs. And I became a teacher. That really became my real calling. As good of an actor as I was, working as a teacher, that's when everything made sense. So
And what did you teach, Jesse?
So, shocker, theater, the arts, working with working with kids of all ages. But the real turning point in my life came when I was invited to work with inmates and addicts. And I say inmates and addicts because they go hand in hand in prisons across Colorado. And I helped co-develop a theater behind bars program with a good friend of mine named Dave Fine. And it was there that the foundation for the victim to victor approach was born. I wasn't calling it that then, but helping men and women tell their stories. This was part of a restorative justice program, a healing program. And intellectually, I understood that the arts had the ability and the power to be able to transform people's lives. I understood that intellectually. I would not have argued with that, but I never had any real experience what that looked like in the hands of using theater and theater tools and working with masks in the hands of people who could care less about theater. They were broken, they were in pain, and something needed to change in their life yesterday. And that's when I became, even though I was teaching this, I became the student to this work.
That's enthralling to me, your prison work. So you would get with the prisoners and actually do theater and have them do some acting.
Yeah.
Wow.
Yeah.
That had to be a tough crowd.
It was until it wasn't. It was until it wasn't. Yes, it was a tough crowd. First of all, it's scary as hell being in a prison, but that's probably why I did it. I'd heard about prison programs. I'd heard about Shakespeare Behind Bars and other programs like that were all part of these restorative justice efforts across the country. So, yeah, going into prison and the doors slamming and the sounds and being in prison makes you grateful for every damn thing in your life. You leave and you want to literally kiss the ground. But then when you saw the men and women who had a sincere desire to turn their lives around, to reframe their lives, then it wasn't scary. And then there was a great sense of play and discovery and curiosity. And so it's funny, this is coming from the theater guy. I resist hearing the word acting because this is Jesse. I will typically associate it with how a lot of people associate it with which is being fake or phony or being somebody that you're not. But there's another part of acting that is about being your truest self. It just gets hidden under a lot of stuff. And working with masks allowed the men and women that I were working with to literally remove their mask metaphorically, symbolically, and step into a different role. And then you saw this extraordinary kind of play unfold that removed judgment, which in my opinion, is the single greatest roadblock there is to being a great lawyer, a great human being, a great witness. And yeah,
Did you say removing judgment?
removing judgment. Yeah. Yeah.
Okay, explain that to me. I'm fascinated.
So mask work, and I don't know if you remember the masks that I had brought
Absolutely.
to the presentation. So yeah, I work with masks. And when I was at Juilliard, I worked with this brilliant teacher named Pierre Lefay, who is the pioneer of working with masks in performance schools all across the country. Although when I was a student at Juilliard, then I think this is the only school that actually really did work with masks. And mask work, if you grab one of these character masks, they are warped and scary and misshapen, and there's nothing friendly or inviting about it. You wear it, and they're villainous and scary, and people tend to play it like that because we have a strong opinion about what is on the surface of this mask. But then a lot of the exercise that I do is about try to find something that's likable about this character. Try to find something that is redeeming about this character. And then when you see people make the choice to find something that is likable, redeeming, something that would make me care about this person, you wear a warped and misshapen mask, and you find the grandfather reminiscing about his childhood, or the old woman who's smelling flowers in her garden, or holding her grandchildren. The sense of play that is designed to remove that judgment, and so you see the mask behind the mask. What that work does, and this is just fun play, is that okay, now let's take off this character mask and let's look at the man or the woman in the mirror. What are we seeing? What's the judgment that we have around this and all that goes with this? And can we get ourselves to a place where we become the watcher? Can we become the compassionate witness to our own lives? And when we can get ourselves to that place, boom, then you got some real magic to work with.
I could listen to this for hours. And I tell you, having experienced it just at one short seminar, I can't wait to do another one. I bet there are some of our listeners right now are saying, okay, theater, prison ministry, masks, how in the world does that help a trial lawyer?
How in the world does that help a trial lawyer? That's a great question. We all wear masks every day. And the word performance gets a lot of pushback. I'm not a theater guy, Jesse. I didn't go to Juilliard, and theater for me, I associate that with dog and pony show. Performance, no. I mean, what you see is what you get. I'm the real thing up there, and that's a performance. So you can call it blobbity cuckoo poo when you're on your feet, but when you're on your feet in front of a bunch of people, that is a performance. How are you showing up at your most authentic self? And there's nothing normal or natural about the courtroom. Give me a freaking break. I don't even know if there's less than 1%. I mean, there's nothing normal or natural about quote unquote being real in an environment that completely conspires against being real. So you've got to find that role and cultivate that role until that role is in your spine. That is a performance. And so when we talk about removing the mask, it's working with the mask. It's having dialogue with the fear of judgment. And can I get interested in the struggle? And one of the greatest things that create authenticity is usually the thing that most people resist and have the most judgment for, which is struggling, the struggle to be on your feet. I mean, I remember, this goes back to my early theater days. I don't remember what it was, what play that I was in. It was a one person show, and you can't run or escape from that. It's just you
You're
on
stuck.
stage. And I was freaking out. I was about to go on stage, and the director puts his hand on my shoulder and he says to me the most sacred words that I will never forget. He says, "Jesse, your struggle on stage is our gift, but it never feels like that to the man or the woman in the arena. But your struggle on stage is our gift." So if we can invite that struggle, if we can allow that struggle and own it, and this obviously works just as much for witnesses as it does for lawyers, then authenticity is born. The audience wants to see that struggle. So I will say, you probably heard me say this line before, but the theater, because I incorporate so much of the theater work into the workshops and the seminars with lawyers, the theater is a safe place to be dangerous, but the courtroom is a dangerous place to be safe. That means you've got to radically trust. That means that careful does not equal credible. So that's a long-winded way of saying when you remove judgment, you set the stage for something greater to emerge. And yeah, I keep coming back to judgment is the single greatest roadblock there is to communicating, to telling the winning story.
Am I right about this? As you're talking, Jesse, I'm thinking about something I've always thought in my practice is that you have to be willing to show your vulnerability a little
Completely.
bit.
Completely.
I have taught that to young lawyers that I've worked with. I'm like, you've got to be humane. You've got to be self-deprecating. Show your vulnerability. That is what juries want to see from lawyers.
Absolutely.
And dadgummit, it's hard sometimes.
It is hard.
You want to come
It
in,
is
you're in
hard.
control. I'm the best. I can do it. I can fight. But to show you're vulnerable is really putting your soul out there.
Yeah, that's right. That's right. I call it armored nakedness. Yeah.
Oh, I love that. Armored nakedness.
Armored nakedness. Yeah. Yeah.
That is really good.
Yeah.
I did a workshop one time with Mark Davis did it with a group of Inner Circle folks with Alan Arkin
Oh,
out
wow.
in Santa
Oh,
Fe.
my God. I heard about that. Maybe you might have been telling me about that.
From what you're talking about right now, it reminds me of what Alan Arkin was teaching us, how you have got to get in touch with your inner self and your own vulnerabilities, your own pain, and let the jury feel that from you in order for them to feel what you want them to feel about your client.
Yeah.
It's sometimes not that easy to do. And you do that with your workshops, don't you? You help lawyers.
Yeah. It is not easy. And it's so easy for me to sit here and say that. What I find to be the bridge to helping remove judgment and the bridge to finding that ability to be your most vulnerable is something that you need to take in with you as one of the greatest allies in the courtroom. And that's your ability to show and connect to awe, the feeling of awe. When you're curious about something, that is much more powerful than being angry or frustrated or judgmental. I'm in awe of this person. I'm in awe of how I feel. I'm in awe of the fact that I want to judge this client. How do we all feel about that? Awe creates the invitation. Awe allows for that struggle to exist in such a beautiful way that creates true connection between you and your listener.
Even just in awe of the process.
In awe of the process.
How beautiful the process is.
Yeah, absolutely. And so if we take that emotion, that feeling of awe. So let's come back to prison.
We've gone through theater, Hollywood, Julliard, prisons. And then after that, I want to go the next step. Oh, teaching, I left that one out. And then I want to talk about how you went from prisons to lawyers. Man, that could be a big step.
Well, you know what? This is your direct. Ask the question and I'll follow. Please.
Okay. I love the prison work. It's beautiful.
Yeah.
How in the world did you go from working in prisons and to working with lawyers?
Yeah.
Maybe there's a similarity there. I'm not sure.
Not that different. I guess we're all sort of in our own prison state, right?
Isn't that the
Some
truth?
literal and some not. Yeah. So again, this is working in prison. And the guy that I was working with, Dave Fine, calls me up one day. It was about maybe, oh, if I'm guessing, maybe about 2 years into the work that I was doing in prison. And he says, Jesse, you might be interested in this. There's a woman named Kathy Osborne who runs a legal conference called 360 Advocacy. And they need a communications guy's storyteller. And this was up in Aspen, Colorado. And I said, yeah, sure. I mean, I'll be happy to do it. At that point, when I was a teacher, you're supplementing your income with everything under the sun. And so I'm like, please tell me I don't have to know anything about the law. Please. I'm like my cousin Vinny character, Blah Dyer. I'm like, what the hell is that? So I go there, and this was in the middle of this blinding snowstorm. And out of the 80 people who were supposed to, 80 or 100 people who were supposed to show up at this thing, I think like only 20 people were there. But out of that group, these were some of my closest friends, clients today. One of those people happened to be a guy named Mel Orchard, who I know you
Oh,
know,
yes. I
right?
love
Who
Mel.
was running
Absolutely.
faculty at Trial Lawyers College at the time. And boy, do we hit it off. And he was like, dude, you are on to something with this victim to victor stuff. And I want to invite you to Trial Lawyers College. And that first workshop, people were coming up to me saying, I'm literally telling my client's story wrong. I mean, I need your help. I got invited to Trial Lawyers College. That was before the big, ugly divorce. And within less than a year, I mean, I was so grateful that I'm saying to my wife, not only can I do this work, I really want to do this work. I'm excited about this work. And I became a human sponge and just sat in every damn courtroom I could possibly go to and absorb everything I could. And yeah, within about less than a year, I'm saying to my wife, this is time. And as much as I love working with kids, I was looking for that next step, and here it was. It was like knock knock, nothing I'd ever would have even thought existed. People like Josh Carton took me under the wing and mentored me, and then I made the big break, and I became a full-time jury trial consultant. So, yeah,
It's one of those things, Jesse, I think was just meant to be.
I think
And I
so.
mean that. I mean that sincerely.
I
I
think
really
so.
do. Tell our listeners what it means, victim to victor.
Yeah. So the foundation for victim to victor, like I was saying, was born with the work in prison. And it was helping men and women redefine themselves, letting go of that judgment. So let's take it into the courtroom. The best example, Charlotte, that I can give for what does the victim to victor approach look like in the courtroom, because it's way more than just, oh, yeah, okay, I'm sure, Jesse, I'm supposed to tell my client, don't be a whiner up there. Well, it goes a lot deeper than that. Let's just imagine we're in the courtroom. And whether you say these words or not, you want to communicate these words only 100,000% of the time when it comes to the right telling of your client's story. Ladies and gentlemen of the jury, my client is not her pain. She is not her pain. So who is she?
Oh, I love that.
She is the strength of trying to overcome her pain. And I can't wait for you to meet her. So these are the three pillars of the victor story: strength, trying, and overcome. When I work with witnesses, we're here to tell the story of strength. We're here to tell the story of hope. And we're here to tell the story of another very, very counterintuitive idea that makes the victor story, and that is joy. I call joy the second wing of the plane to the victor story. So now take that statement. My client is not her pain. She is the strength of trying to overcome her pain, and I cannot wait for you to meet her. And just compare that to what is the common description of the witness that you will hear coming from many lawyers' mouths painfully. Ladies and gentlemen of the jury, my client is her pain. And you're going to hear about all the things that she can't do. She can't. It's another word that I absolutely say don't ever say. And now give us a lot of money. Good luck with that story. Not to say you can't get good results with that. Some have, but you maximize the living you know what out of your damages. Full justice when you reframe your story around strength, hope, and trying, and joy despite the pain. And joy gets it gets a lot of pushback, just as much as saying the word theater or performance. We could talk about that in a minute. But that is, in essence, what the victim to victor approach looks like. And it's way more than just casting your witness in the right role. It's how you frame your entire case.
I literally, when you said my client is not her pain, it made me want to sit up on the edge of my chair.
Isn't
And
that
I'm sure
interesting?
that jurors have that saying, oh, what is she? Tell us
Yeah.
about her.
Imagine those words coming from a lawyer's mouth who's there. Wait a minute. What that does is kind of wrangles my thinking, the cross-armed jurors thinking around the bias that I have towards you. You say your client is not, I'm expecting you to say how messed up her life is and how da 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 da. And it's just been, she can't. I'm expecting sympathy. I'm expecting manipulation. And you're saying that your client is not her pain? Whoa. You're
Okay,
right.
here's my. I've got so many questions, and we
Fire
have such a
away.
limited amount of time. The one that stopped me a little bit when you said the joy. If for
Yeah.
instance, you have a paraplegic or a quadriplegic client,
Yeah.
and you're talking about joy,
Yeah.
explain that to us.
Can I ask you a question?
Absolutely.
Was there ever a time in your life when you've experienced what you would consider to be a life altering injury or just a hell of a lot of pain?
Absolutely.
Yeah. And when you felt that pain, either physical or emotional or both, how good did it feel to be able to laugh a little bit?
It breaks the pain to an extent.
Yeah. How good did it feel to be able to laugh a little bit? How good did it feel to be able to be a little bit distracted? How good did it feel to be able to just do some of those little things? And those little things become your entire case. You magnify those little things because when you're in a lot of pain, ain't nothing little about little. Those little things aren't little, they're big. So when we, the jury, see somebody who's able to find a little bit of joy in their life despite the pain, what you end up doing paradoxically is magnifying the pain at an even greater level and allow the jurors to want to be able to fight for that person to be able to have just a little bit more of that sliver of light.
I love that. How would you do that, Jesse, for instance, if you're representing the parents of a brain damaged baby? How do you talk about joy in a case like that?
Yeah. Yeah. Where's the gratitude? I worked on many of these cases. My child is brain damaged. And yet, but despite, and despite is one of my favorite words in the courtroom, are there moments when they're able to make that brain damaged baby smile a little bit?
Smile, yeah.
Are there moments when the mother and the father, when the child is sleeping, can go in the other room and watch Dumb and Dumber? Let's just get away from it all. Yeah. Are there moments where they think, you know what? Brain damage does not define my child because I'm seeing things that prove the people who are saying she can never do this wrong. I'm not seeing it yet, but I'm hopeful. There's tons of joy. You just got to know what you're looking for. Don't ever allow pain to be the excuse to not find joy because it's there. It's there. And I get, sorry, I know you're going to ask me, but I
No,
get pushed
I am
back.
so moved.
The best, I get so excited. I may be the one person in the country who gets really excited when I get the call and says, Jesse, boy, this person is a victim. Oh my God, they're entrenched in the victim trap. I mean, they're just buried in, there's no joy in their life. And I'll have witnesses who actually get downright offended. And understandably, I'm not there to judge. When I say to them, I said, Miss Jones, next to telling the truth and on the stand, does it surprise you when I tell you that the single most important thing that you can bring into your testimony, whether it's deposition or trial, and they're one and the same in my mind, is joy? Pause, pause, pause. What? Joy? I'm the victim here. There's no joy in my life. Oh, let the games begin. Yes, there is. And we're going to find it.
And that's how you work with clients and witnesses.
You bet. You
Oh,
bet.
man.
Absolutely. Within the first 5
All right.
minutes, they need to know their role. They need to know what the battle strategy is. And even if it feels forced or manufactured right now, there is joy. One of the first exercises I do, it's an icebreaker, but there's real practicality. Everybody in the room, lawyers, or if I'm working with one-on-one with a witness, what's something in your life present day that puts a smile on your face? Something that makes you laugh. It's hard to find somebody who not able to find something. And let's say, okay, there's nothing in my life that makes me, okay, all right, which is rare. Is there a movie that you like? What's one of your favorite movies about a character that doesn't give up? I'll find it. And then there's a little bit of joy. That's all I need. That's all I need. That's the sliver of light. That's the candle in the darkness. Now I got something to work with.
All right. I'm absorbing all this. It's amazing. At what point do lawyers normally hire you to work on a case? Is it when they're getting ready to put their client up for deposition, before trial, at the start of a case? How does that work?
Yes, yes, and yes to everything that you just said. Yes.
Well, let me start it this way.
Yeah.
What is ideal?
The ideal is if you can. I try to work up a case as far in advance as possible. And that will usually entail about a 2 to 3 day prep. And there are two main areas that I will focus on. And they're pretty broad when it comes to the second one. The first one is witness preparation. That's where you always want to start. It's getting the witness cast in their right role. But I'm wearing a lot of hats during that work. I'm working on the verbals, I'm working on the nonverbals, I'm working on the delivery, I'm working on making sure that they know what their role is and what their role is not. And there's a whole checklist that I follow. And if you're working with the person who thinks that they're the smartest person in the room, they need to know it's not their case to win. So that's all part of the act one. That's the witness preparation. And then typically it will roll into trial strategy. Now that we know what the victor story of the client is, now we get to frame this case. Now we get to put it together. Opening statement all the way up to rebuttal. If you read my second book, I like to begin. The final chapter is begin with the end in mind, which is once you understand your rebuttal, then it helps you frame the moral framework, as Mr. Friedman would say, of your entire case. And then from there we go, okay, now we understand what the right story is, what the right story is not, what is his case about. Then, yeah, we go to opening statement and then jury selection. That becomes the right conversation that we have with our jurors. The one thing I don't do, and I used to do it before, is pick a jury. I will frame the right conversation and the themes and the topics and all that good stuff. But I won't pick a jury because that's just way too time consuming, and it's a whole science and there's people who do it way better than I do. But short of that, yeah.
But you'll help the lawyers formulate questions for voir dire. We
Oh,
call it
yeah.
voir dire in Texas.
Yeah. Voir dire. Voir dire.
Voir dire. You say voir dire in Texas.
I just call it
and you're
jury
gonna be in
selection.
trouble. Jury selection. There you go.
Yeah.
I love it. I love it. So when you're working with lawyers and talking about jury selection, what types of questions do you recommend? Give us some examples of the Jesse School of jury selection.
I don't take any cookie cutter approach to any case, but there are questions that I do like. One of the questions, and it comes back to, I was on a podcast recently and they were asking me, okay, well, what does victim to victor look like in jury selection? And typically I will work on, I would say maybe 80 to 90% of most cases that I work on are invisible injury cases. Specifically brain injury, but also, the reason why slip and falls and the reason why the defense is saying the reason why the plaintiff looks fine is because they are fine. So the real opening statement for me is jury selection. And that's where you're priming the pump. I'm not telling you or anybody listening what they don't already know. But one of the questions I like, and I used to be sort of like, well, maybe you're tipping your hat off too much to defense if you ask this question. To me, I think it's a great question. I wouldn't hesitate to ask it. There might be a really good reason, and I'd be open to that. But more often than not, asking this question gets you in the door to get the jurors on board with what they need to be seeing when it comes to the right telling of your client's story. So it's a two-part question. It's actually similar to what I asked you earlier. Part one question is, who here knows of anybody who has experience, and maybe it's you, what you would consider to be a life-altering injury? What does that look like? And get all sorts of shares around that. That primes the pump then to get into the second part of that question. This one I love. And it goes back to the mask work. Who here knows of anybody who, despite their pain, are doing the best they can to try to hide their pain? What does that look like?
Oh, I like that.
You get some great stuff there. So what I'm hearing you say, Mr. Jones, is your grandfather, he's like Father Christmas to your grandkids and to everybody in your family. But what are you seeing? You're seeing something completely different. Behind closed doors, what are you seeing? Oh, man. I'll tell you one thing. It ain't Father Christmas. Thank you, sir. more shares, more shares, more shares, more shares. So earlier, I introduced you to my client. They were smiling and they were talking, and then I asked them to leave the room. She looks fine, doesn't she? Everybody agree that she looks fine? Let's talk about that. That's why we're here. So I'll take that conversation and then direct it right back to the person that I just excused.
Man, that would be so good in sexual assault cases as
Oh,
well.
hell yeah.
I mean, really, I'm just sitting here thinking how powerful that could be.
Yeah,
Because sexual assault survivors often want to bury their pain. They do not want to talk about it.
absolutely.
So let me ask this. You said that you looked at my client and she looked well. She looked fine.
She looked fine.
Do you recommend that lawyers have their clients present during voir dire or jury selection?
I don't.
Okay. I don't either. I don't
I
have my clients
introduce
there.
the client and then I have them leave.
Okay. So
Because
you
I
actually
want a
have them
devil's
physically
ad-
there at first.
Yeah, absolutely.
Okay.
Yeah, introduce them, let them see it. Let your jurors know why you've chosen you're telling them to leave and why you're making the decision. More often than not, follow this. Why you're making the decision to not have your client mostly there in trial. And the only other time you're going to see that person is when they're on the stand. Some cases depend; it varies, but for a brain injury case, especially, I wouldn't have the client there. But let your jurors know that. And if they push back on that, yeah,
I always, tell them my client's not here, or I ask them not to be here and explain it. But I love having the client there introduce them so the jury can see they do look normal.
absolutely.
And then you can really ask the questions. That is brilliant.
Well, and here's the fun part, okay? And this is why I'm not just being cute. This is why I say jury selection is really opening statement, is because and I, shameless plug, I write about this a lot in a number of different cases where I use this approach when it makes sense in book 2. When you get into opening statement, and I have to say this with a preface, is that David Ball is a very good friend of mine. But he gave me a lot of pushback when I first was about to go live with this statement, and I thought I was backing it up in my book. He was so supportive of book 1 and book 2 when I said you don't always need to start your opening statement with the defendant's story. Sometimes it makes sense to start with the plaintiff's story. And I mean, he ripped me a new one. And it wasn't, you can understand why. And it wasn't just because I thought I did my job. I mean, well, look, here's this case and here's this case and here's this case where it worked. And that wasn't good enough. So I grabbed my good friend, John Campbell, and we scienced the crap out of it and we backed it up. And that was his whole point. Whole point is that if you're going to make that statement, back it up. Why does it work on a neuroscience level and all that stuff? Anyway, now we're great friends and he's a great supporter. But I mentioned that because, again, you don't always need to start with the defendant's story. If the bias, and it comes back to the question, who here knows of anybody who, despite their injuries, are doing the best they can to try to hide their pain? It opens up the door to have a really rich conversation about invisible injury. Even, if I can prove to you that this person there's a lot more going on. Mitnick says, don't judge a book by its cover. I can show you there's a lot more going on than this surface, the mask, what the rest of the world sees. Who's going to give me a shot? You've had all that. You've had that conversation in jury selection. Now, opening statement. I call this the dead body in the water approach. My buddy Brian Kim and I, he's a great attorney, great friend out of LA. We called it the dead body in the water approach. When it comes to beginning your opening statement, when the attack against your client is the reason why they look fine, and it's because they are fine. I would never do this approach if the injuries spoke for themselves. If the injuries were obviously catastrophic, you don't even say good morning. You stand up. Okay, counsel, you may proceed with opening statement. Thank you, Your Honor. You have your client stand up. You don't tell them. You never tell them ahead of time, so they're surprised. Go ahead and stand up. We'll call this guy, we'll call him Jonathan. This is the guy that I write about in the book. Jonathan Shoto is the name of the witness. Jonathan, go ahead and stand up. This is Jonathan. He looks fine. And we would agree. He looks fine. He's going to walk. He's going to talk. He doesn't have what they call cane pain. And he's going to sit up there in this place where we tell the truth, and he looks fine. But if you had x-ray goggles and you were to look inside his body, here's what you would see. and you describe all the stuff that the rest of the world wouldn't see. So you get to ask yourself, is this person a liar, a cheater, a fraud, or not? I mean, I'm paraphrasing. That's the idea. And then you excuse your client. So let's talk about why we're here.
Have them leave the courtroom?
Have them leave the courtroom. And let's talk about why we're here. And now you get into the defendant's story. Because what have you just done? You've taken the defense's greatest attack and you've shoved it right up their wazoo. The juror's greatest bias. They either are going to think that you're full of crap or not. So what do you got to lose? Why wait? Why wait to tell your client's story? Because if that's the biggest bias, does this person have a brain injury or not? Is this person is really messed up or not? Is this person, the reason, and they're saying, well, this is jackpot justice, litigation lottery, and they quit their job and now they're just looking for a handout. That's the biggest bias. So why wait for it? Get right up in front of it. Get ahead of it. And because you've already had that conversation in jury selection, they're not going to be all that surprised when you say, Eddie, Sarah, go ahead and stand up.
And I love that you don't rehearse this with your client because it's been my experience. I've been doing this 40 years. And when you rehearse things like that with clients, juries can smell it a mile away.
Oh, yeah. It's canned. I mean, then it's dog and pony show. I am a big believer. I know the word rehearsal gets a little, but in preparation, I don't think you could ever overly prepare. I honestly don't. It's how you are preparing. What is your goal? And your client eventually is prepared to be in a place to expect the unexpected. That's proper preparation. But when it's canned, when it's, all right, now just know when I stand up, I'm going to say, go ahead and stand up. And I want you to, then the jurors are going to be like, oh God, they're going to throw their tomatoes at you. Rightly so. So
let me ask this, Jesse. If you have a catastrophically injured client, I assume that you would do what David Ball would say in the opening is about the defendant.
Depends.
Okay, on what?
Depends upon how much you trust that story. Depends upon how much you radically are going to trust what your jurors are going to come to the conclusion with. They're expecting you to blast away the defense. They're expecting that, and I'm not saying don't do that. I quote Bruce Lee all the time in The Most Important Juror. The most important juror is you, by the way. His famous line is, be water, my friend. The only absolutes is to tell the victor story. That's my opinion. And I know that's probably very controversial. I understand the science. I understand all the reasoning behind why you would want to start with the defendant's story. But I also subscribe to a great lesson that I got from the theater, a great lesson from the stage. Don't give it away so cheaply. And here's where the power of joy comes into play, Charla.
I love that.
This is where joy really works in your favor, and it's not just for the client. I would like to circle back on, we didn't really talk about the power of joy and why that's where it's not just about making your client likable or relatable. There's a real practicality when it comes to damages. But using joy in opening statement, I'll give you an example. A hook line that I like if you're working on a trucking crash, catastrophic injuries, or wrongful death. We all share the road every day with other drivers. And that's a line everybody can relate to. And then you could even throw in a rule. When construction, I'm going to line that I'm working on a case right now. When construction companies put unsafe drivers behind the wheel, people can get hurt. Now, what's the expectation? The old school way is, let's talk about who this defendant is. You're going to learn about this trucking company. You're going to let me tell you the stats of this company. And they're a trucking company, and they've got a big fleet, and they're all over the. But if I've started with that hook line, I've made a bank deposit. There's something. Oh, that's scary. We all share the road every day with other drivers, and then I've given you a rule. When construction companies put unsafe drivers behind the wheel, that some people can get hurt, or that puts us all at risk. That's a little golden rule, but people going to get hurt. And in January 2024, somebody did get hurt. Okay, so you've got that there. Now, because I've made that bank deposit, I can make a withdrawal. I go into joy. I want to take you to 4 or 5 years before this crash happened. And I give you a scene of joy. Or I can maybe take you to 2 days before the crash happened, or the night before, where there's a scene of joy. Father's excited. In the future, he's going on a road trip with his family. Daughter's about to graduate. Morning of, wife gives him a big hug, kiss on his neck, and says, "Okay, baby, I'll see you this evening. Date night tonight. Okay, whatever it is. Okay." That's a little bit of joy, because what does joy do? And this is what I'm looking for in every opening statement that I'm working on, Charla. Whether it's, I don't care what the case is, whether it's a med mal case, TBI, whatever it is, I'm looking for impending joy, impending doom, because impending doom is the thing that's going to create suspense, it's going to create betrayal, and it's going to magnify the damages at an even greater level. When everybody, they're not idiots, they know why we're here. They're expecting the crash. Okay, let's get to it. What happened? What happened? Build it up a little bit. And it doesn't have to be much. You just build it up enough a little bit to then, just at the point where we think that, okay, we're going to get to the crash, then I might tease it out a little bit more. Okay, so if I've given you joy, and then I take it right up to maybe the part where, and then I get the client on the road. Now let's talk about this company and who they are. And they're a big fleet, and and they've got over 5,000 trucks, and they started here, and da 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 da. The jurors have a mental picture of the client who's already on the road. I've used that joy to get him there. Then I could go into an opening statement. I could tease it out a little bit more. Again, not every case is the same, but more often than not, I like to go with a happy ending. Let me tell you a story that has a happy ending. The defense does this and this and this, and we're not here. I wish I could tell you that story. But if that were the case, we wouldn't be here. So let's talk about what actually happened. So I've blown up the balloon, and now I'm slowly popping the balloon. It's a slow leak. They did this, they did this, they did this, they did this. Now I'm creating the feeling, holy shit. Sorry, can I curse a little bit on here? Is that okay?
Absolutely.
Okay, all right.
Yes.
Holy shit. It's not a matter of if, but when. And then, boom, then I get into the crash. Now you throw in the rules. Now I love the rules, but the problem with the rule is I don't care when you tell me them. If you give me a reason to care about the rules, then I'll care about the rules.
I love that. So you talk about the joy in opening.
Absolutely.
Even board ire.
Oh, yeah.
Jury selection.
Absolutely. Joy is the defense's joy killer. Joy, let's come back to, can we shift back to the witness and why joy works?
Absolutely.
And why I call joy the second wing of the plane to the victor story.
Sure.
Most people don't think of joy as evidence, but it is. And it's one of those things that's so obvious that we forget about. When the witness is on the stand, is it important that they're likable, that they're relatable? Yeah, that would be great. Although I maintain you don't always have to have a likable client. And you, the lawyer, don't always have to like your client. But that's a whole different thing. By the end of the case, it'd be shocking to me why you wouldn't like something about them. But that's a different story. We could talk about that later. But for the cross-armed juror, how can I know the value of what's been taken from your client if you don't show me the value? What's that value? Joy. Joy. And so when the witness is up there, let's just say they've had a really, really tough life. Okay, let's just say that it's not that much to talk about how life was so joyful before they got hurt. I mean, I worked with a woman the other day who her whole life, it's a really, really tough case. I mean, she's an abuse survivor. I mean, an abuse survivor, like not just like dad was mean to me. It was awful, awful, awful stuff. Wasn't a lot of joy in her life, which makes the one thing that she had like a candle in the dark. I steal that line from Mo Levine. And we magnify that candle in the dark. The one thing that she was good at was being a surrogate mother to these two boys. She was good at that. Everything else in her life was a shit show, except for the one thing in her life that she was really good at. And when she talked about those two little boys, she lit up like Christmas morning. We finally found it. We finally found it. That joy is evidence. How can I know the value of what's been taken from this person? And talking about joy ain't the same as showing it. I could say to you right now, say, Jesse, tell me about your son. What is it about your son that gives you joy? Go ahead and ask me that question.
Jesse, what is it about your son that brings you joy? I can look at his pictures on Facebook and tell you.
Yeah, well, that's cheating. But yeah, okay, let's pretend you've never seen that picture. But go ahead and ask me that question. I'm just going to give you...
Jesse, what is it about your son that brings you joy?
Well, among many things, he's a wild man. And he likes to rock out and pretend that he is like Pete Townsend from The Who. And he just likes to wave his arms up and down and jump around the house. And he puts on a show for his mom and I practically every night. Well, I told you about joy, but what was missing?
Smile.
Joy. Talking about joy ain't the
It was
same
not
as,
very joyful.
right.
So let me ask the question again then, Jesse. What is it about your son that brings you joy? I love it.
He's a wild man.
Yeah.
I didn't have to say much, did I?
No.
I didn't have to say anything. So that's the power of joy. We get it. And I steal this line from Maya Angelou. Jurors never remember what you say. They remember how you make them feel. Within one less than a nano instant, I gave you the value of my connection to my son. We're not going for theatrics here. This ain't acting. It's a sliver of light in the darkness. That's all you need. You just need the witness to be able to connect to that joy. You see it, we see it. You feel it, we'll feel it. It's the alchemy of communication and connection. We get it without having to give me a PowerPoint for the things that gave you joy. But what you're doing with joy in direct with your witness, I've got the 3 acts of direct examination that I walk witnesses through. That's the structure of the victor conversation. I also call Act 1 the bank deposit, because when you deposit the joy, now you get to withdraw the pain, which gets us into Act 2. And Act 2, I call it, I steal this line from the Navy SEALs. You probably remember me saying this. I call it embrace the suck. Embrace the
I do
suck,
remember
not
that.
tiptoe around the suck, but embrace the suck. But there's a caveat to it. I have the witness actually write these down. There's very few times I have the witness write stuff down when we're working with them. But this is so important because Act 2 contains just as much pivotal joy as Act 1 and Act 3. And that's embrace the suck, but get to the but. And it's the one time the witness can ever volunteer any information. Preparing for deposition and trial. You never want to guess. You never want to volunteer any information. You only know what you know. This stay in your hula hoop, all that stuff. That's standard stuff. Except for one time, and one time only, I instruct the witness. You can ever volunteer anything. And that's when you get to the but. And the but is the victor story. And what I mean by that, can I give you a brief example of that?
Yes.
Okay. You might have heard me share this before, but it's one of the best examples where the witness on the stand volunteered the but. It was beautiful. Almost word for word. It's one of my favorite. I got so many examples. I got witnesses all over the country, by the way. They shoot videos of themselves to practice the suck to butt scenes, to be able to practice joy. To literally,
I love that,
like,
the suck to butt.
suck
You're
to
not going to
butt.
forget
Yeah.
that one.
Somebody suggested that should be the title of my next book.
I don't know about that. I kind of like it, though.
Yeah, well, I mean, it's a grabber, right? So this witness is on the stand. She had this thick Brooklynese accent. Her husband, we'll call him Frank, we'll call her Edie, had been killed in this horrific trucking crash. She's on the stand and she says, after Frank was killed, I could barely get out of bed. Feeding was an impossibility. My kids literally had to feed me and scrape me out of bed just to eat. And one morning I thought, that's it. I'm done. Stick a fork in me. She pauses and she pauses and she pauses, and tears are coming out her, running down her eyes. And God bless the lawyer who didn't try to save her, who kept her in the suck. God bless that lawyer who didn't try to rescue her and go on to the next thing. She eventually found the butt. She looked across the room. But when I look across the room, she says, and I see that picture of Frank with that goofy, stupid, smiling look on his face, and she starts to smile. I took that picture about 2 weeks before this happened, she says. She looks at the jurors. I heard him say just as clear as day, Edie, get your ass. I'm sorry, Your Honor. Can I say these words? Thank you. Get your ass out of bed. And so I took the next step. And guess what? I'm still walking. Woo!
That gave me goosebumps.
Game-changing moment.
Literally.
Because she knew her role. And the lawyer knew her role and knew his role in, ladies and gentlemen of the jury, my client is not her pain. She is the strength of trying to overcome her pain. So in this scene, he backed it up. He literally could have turned to the jurors and say, did I not tell you?
Yeah. Oh, that's beautiful.
And that kept her in victor lane, not victim lane. So yeah, joy is just as important in Act 2 as it is in Act 1, maybe even more.
All right, we're getting close to time, but yeah. I've got a few. I'm going to have you back on the
I would love to. I love talking to you. I really do.
Yeah, I feel the same. I got to ask you this. I always ask lawyers this. How important do you think closing argument is? Do you think that is where you win the case because that's when the people come to watch and it's so exciting?
No, it just confirms what they already believe. Yeah. You're putting a bow on it. Yeah.
Okay, that's exactly what I
Yeah.
thought. You've given us quite a few case examples here, Jesse, but can you think of any particular case where reframing the witness or story dramatically altered the outcome, where you went
Yeah.
in and it was all okay? Can you just tell us one?
Yeah. Yeah. Well, the case that I was just talking about, the dead body in the water example, and I write about this in this one in book two. This is where I really, really trusted with Brian Kim the power of getting in front of the attack. The reason why why the plaintiff looks fine is because they are fine, is what the defense is saying. This was a slip and fall at McDonald's, and I joke that the only other bias that's bigger than the the bias against McDonald's is a slip and fall at McDonald's.
That's
Yeah.
the truth.
Yeah.
I mean, I don't know if I'd take that case. I love it.
Yeah, I mean, it was so big. I mean, and it was, the jury selection was a battle, and jurors pushed back, and then Brian stood up there and he said, "So listen, if you thought this was one of those cases, it's not, and give me a chance to back it up." But what was great about that trial, and this came from the witness again, really knowing their role, and this just happened organically. It was a beautiful thing. This is where it does make sense to have the witness in trial. Absolutely made sense for Jonathan Chota, the plaintiff, to be there in trial. His mom gets up on the stand. Now, I hadn't worked with mom in my defense, so, otherwise I would have. But she gets up there and she starts talking about all the things her son can't do. Oh, no, he can't do this, and he can't do that. He absolutely can't do that. Oh, no, he can't do that. He used to be able to do that. And she says, the water works. And I'm like, oh, shit. So Jonathan gets up on the stand, and Brian Kim says, "Jonathan, hearing your mom saying all this, what do you have to say about that?" He said, "It makes me angry. I mean, she's my mom, and I love her, and I get it. But that's not me. And it makes me feel, boy, if she's seeing that," I mean, I'm paraphrasing, but if she's seeing all the things that she's saying, that tells me that I need to work even harder to prove to her that I'm not that person. So we managed to rehab it, but pushing back on Jonathan built not only his credibility, but ours as well.
I
Yeah.
love that.
Yeah. But
And I think in that particular case, I can understand how a jury would think a mom is going to try to, say all the things that he can't do. Although if you'd worked with her,
right.
she probably wouldn't have said it that way.
Right. Yeah, well, yeah, that's right. I would have like, oh gosh, Jesse, come on. But yeah, no, there was another case, and this is very similar to, this was a recent one where I actually wrote about this story. It was so interesting how it's paralleled to what I wrote about in book one. This is a school teacher. Again, that one sliver of light, the one candle in her life that was her life before. And this woman had flunked, like, I want to say 3 or 4 focus groups, which is, again, I mean, not a bad thing. I mean, I think ultimately the result you want from a focus group is more negative reinforcement than positive one. So you know what to do to pivot.
Right.
But it was pretty bad. I mean, everybody was like, "Oh my God, whiner, malingerer, victim, 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 victim," and defensive and argumentative. And I worked with this woman for a while and got her to change her relationship to her listeners. Is something I talk about a lot. Is that you can go through all the different cosmetic exercises and they remain simply cosmetic, and smile, and less is more, and look at your jurors and body language, and it will be meaningless if they haven't, and they may still understand intellectually their role as victor. And the biggest confirmation that bias that you see is in the witness, who just cannot get themselves out of victim trap. So this woman was able to change her relationship to your listener. What I often say is, when you change your relationship to your listeners, not only does the conversation change, but you change. She literally, this is the power of visualization and belief. She literally saw her jurors as her dead sister. And because I asked her during prep, who's one person who needs to hear your story? Imagine if there was that one person who, when I worked with inmates, I would say, if you could save a life with your story, would it be worth it? And nobody's ever said no to that question, because ultimately you get yourself to a place where the story is no longer about you, but about inspiring your listener. She got herself to that place. Her sister took her own life, and she imagined the conversation of what it would look like if her sister, were to hear her story, her sister's story, the plaintiff's story, and about not giving up. And the plaintiff, we'll call her Joanne, Joanne said, yeah, I believe that she would have heard this story from me. It maybe would have given her pause because she would have said to herself, Joanne, if you can do this, I can do it.
I can do
That
it.
was all a part of that was the personal connection. And then when she got off the stand, I said, how'd that feel? She said, ask my sister. And because she imagined that she was talking, I said, well, what do you think your sister would have said? She said, I'm proud of you, Joanne. And the jurors have, of course, no
I
idea who she
love
was
that.
talking to, but that armored nakedness, that vulnerability came through, and we got justice
I
for her.
absolutely
Yeah.
love that story. Okay, Jesse, what advice that lawyers listening today need to do immediately on cases besides hiring you?
Yeah, right. You got to know what story you're telling and make a choice. You're either going to tell the victor's story or the victim's story, and it's that simple. You're the director. We hear the word storytelling all the time. Storytelling. And yeah, you are a storyteller, but you're a director. And great directors know what they are looking for. Great directors are always finding the fight in the character, whether it's on the page or not. They know what they're looking for. Cast smartly. And that begins casting yourself in the right role as well. And then I would say, once you've made that choice to tell the victor's story versus the victim's story, trust the joy.
God, I love that. I love casting yourself. I mean, which role am I going to have here? That is absolutely beautiful. All right, Jesse Wilson, how can people find you? How do they contact Jesse?
Really simple. Tellthewinningstory.com. That's my website. My email is
that
Jesse.
really your website?
Yeah.
Tellthewinningstory.com.
Tellthewinningstory.com. That's really my website. And then my email address, Jesse, Jesse, at tellthewinningstory.com.
Jesse at tellthewinningstory.com. Thank you so much for
Thank
being
you
here
so
today.
much for having me. It was so great talking to you.
We're going to have to do this again. I loved it.
Anytime.
Okay. Bye-bye.
Bye.
Thank you for listening to another episode of More Likely Than Not. We look forward to seeing you next time. I think you can tell, and we at Aldous Law here, we actually kind of like each other, and we absolutely love what we do. And we work a lot of our cases up from the get-go, but we're brought in on cases a lot. We try cases all across the nation. If you have a case that you're interested in talking to us about, we'd love to hear from you. We've tried everything from trucking, workplace injuries, explosions and burn cases, dram shops, rideshare sexual assaults, birth injury, your personal injury cases. If you need a partner to help you with your case, please call us. We can be contacted at aldouslaw.com. We'd love to hear from you.
You've been listening to More Likely Than Not, where the Aldous Law team turns small margins into massive victories. Love what you heard? Don't miss an episode. Subscribe now, leave a review, or share this with a fellow trial warrior. Remember, we're all just 0.01% away from tipping the scales. Produced and powered by LawPods.